With
Thank you, Judge. May it please the court. And you can go to the first slide. In February, so let me start with this. There's a story here that's largely undisputed, but it can really get lost in objections and procedures. And so I'd like to talk about it big picture and then break down each of the elements and fully open. I have those added out with the evidence for each. But the story is that in February of 2018, Martin Floriani was removed as FloSports CEO. He was frustrated. He was highly motivated. He's highly intelligent and entrepreneurial. And he pursued ideas about cryptocurrency, paying content creators with cryptocurrency that he started at FloSports. He brought on FloSports personnel. You saw the Flow Plus slide that was in their investor deck and touted that to investors. He began what was ultimately a successful 9-month effort to pursue Willie Saylor to quit his job at FloSports and to join Rockfin. He said, and can we get that slide? He said, "You will be the flywheel that we need. We need you. We need a flywheel." So when the court said that came from the plaintiff's lawyer, it did come from the plaintiff's lawyer via Mr. Floriani in February of 2019 when he first started this 9 months of attracting Mr. Saylor. Now, Mr. Saylor, for his part, was interested but hesitant. And you go to the next. And although it counters the model that Rockfin claims to have, Rockfin promised Mr. Saylor the security that he wanted. In launching, you can go to the next one. In fact, he got really aggressive about it as he went along. That's according to Mr. Floriani's own testimony. In launching Rockfin, Mr. Floriani was interested in developing the wrestling content because it's what he knew. He was a college wrestler, but also he knew the lucrative value of this vertical at FloSports and what it could do for Rockfin. He attracted elite wrestlers like Ben Askren and Jordan Burroughs to Rockfin, and then he assisted them in producing their content. And you've seen the holding the camera while these folks talk about their master classes, et cetera. In that flywheel email from February 2019, Mr. Floriani told Mr. Saylor, "I have 81 people in the wrestling community that I want to reach out to, and you're the guy to do it." He also began conversations with important media rights holders for FloSports. Now, Mr. Floriani knew the value of Mr. Saylor's content in the wrestling community. Mr. Saylor's rankings in particular are very interesting to collegiate coaches who also hold the rights to a lot of the live events. And so Rockfin lured Saylor with flattery, with plenty of the personal attention that Mr. Saylor craved from Mr. Floriani. Mr. Floriani, you'll recall that he called Mr. Floriani his God in some of these texts. Mr. Floriani flew to Pennsylvania to meet with Mr. Saylor, and then he flew Mr. Saylor back to Austin to learn the Rockfin system. Mr. Floriani also lured Mr. Saylor with suggestions of huge compensation over time. He said year 2 would be exponentially large, but that year 1 would be just about what he made at FloSports. Mind you, he sent that in the wee hours of November. These are models that are in the record at F664 and F562. Mr. Floriani sent these financial models in the wee hours of November 2nd, 2019, as he was coming back from Pennsylvania. And Mr. Saylor quit FloSports that very evening. Mind you, Saylor had already had a written offer in hand from Mr. Floriani by that point. Now, Rockfin's 9-month persistent pursuit of Mr. Saylor finally paid off in November of 2019. And he joined as a W-2 employee. Rockfin paid him a $10,000 bonus, 9 months of health insurance that just ended about a month ago. And Rockfin paid him a salary and bought Saylor studio equipment to replace what FloSports had provided. Saylor quit FloSports that same night. He took ranking spreadsheets that he developed over 8 years at Flow Sports. He accessed Periscope after he quit. He removed his rankings content that was publicly facing on Flow Sports and put it on Rockfin. And he did a podcast where he disclosed confidential information about wrestling coaches. Saylor and Rockfin then began aggressively promoting Saylor's presence on Rockfin through social media, including by paid ads that Rockfin paid for, targeting the Flow Sports Wrestling, the Flow Wrestling audience. And the benefit was substantial and immediate. Subscribers on the Rockfin platform, which had been really stuck since it began at about 1,000 subscribers, promptly doubled to 2,000 and continued to grow more rapidly after that. Mr. Saylor really had become the flywheel. And the real payoff came in September of that year. And of this year, if you'll click forward, when Mr. Cale Sanderson from Nittany Lions Wrestling Club reached out to Willie Saylor. Now, Willie Saylor had by this point created buzz around wrestling and had become the flywheel in terms of wrestling. He reaches out to Willie Saylor to ask about streaming the matches for NLWC. You can go to the next one. Those aired on Rockfin exclusively. And then you can go to the next. And resulted in a doubling again of Rockfin subscribers. Mr. Floriani testified that securing this event was the single most impactful development in Rockfin's history. In terms of subscribers, the only way that it could be rivaled is by Willie Saylor joining the platform in November of 2019. With the addition of these live events, and it's a series of events, it's not just one event, Rockfin's and Saylor's plans had come to fruition, and they were rapidly growing their community of wrestling subscribers and their important live events and competing successfully with Flow Sports. So let's talk about the causes of action here. Starting with breach of contracts. Okay, and as we know, a deal is a deal, and this contract had consideration. Can you go to the next? There you go. Next. Mr. Saylor does not dispute that he received confidential information in accordance with the non-compete as required. Let's go to validity. Next is the PIIA. And you've seen this so many times, you probably don't want to see it again, but there was a provision that we just talked about that I want to make sure and show you. You can see that both Martin Floriani and Willie Saylor signed this. And in fact, next, you'll see that you remember that Willie Saylor testified that Flow Sports took this requirement to get non-competes very seriously, that they pursued him multiple times, and certainly not to keep him from competing in a way, doing something that he never did. Next. They took these very seriously. In fact, Mr. Floriani testified that absolutely not. He took these agreements very seriously. Breach. Next. And now we have the breach. Let's go to the first slide on breach about non-competes. So the acknowledgement of the business of the company is an acknowledgement of what the company did, provided products and services in the sports video industry. Products and services in the sports video industry. It didn't require him to be manning a video camera. Now, the first part of the non-compete isn't linked to that definition at all. It's simply, you can't compete. And certainly that's what's been done here. Let's go to the next. Of course, there's a non-solicit, and next. And there's an agreement not to disclose confidential information and to return company documents. Both of those have been breached here. Next. This is the provision that I was referring to earlier, and I called it 10.2, but it's 3.2. In his non-compete, Mr. Saylor agreed, or in his PIA, he agreed that the term of the non-competition and non-solicitation provisions located in this paragraph will be extended by the amount of time during which I engage in any activity that violates these provisions. So this is actually a contractual tolling, not just an equitable request for tolling. Next. As we discussed, there's multiple times where the contract says that there is no waiver, that it cannot be waived by some kind of selective enforcement or otherwise. And now let's talk about breach. The non-compete includes you can't compete, you can't own or control competitor. That's where business of the company definition comes in. You can't perform the same or similar duties for a competitor. And we certainly know that Mr. Saylor is performing the same or similar duties, both for Matt Scouts and for Rockfin. You can't disclose confidential information, and you must return documents and data. Next. Now, when the defendants are not running their thoughts through a litigation filter, their evidence is a little more direct. Like when Legacy can't compete and innovate, they make moves like this. It's Martin Floriani talking about Flow Sports, saying that Flow Sports cannot compete. Next slide. And when Christian Piles asked Willie Saylor, why did you go immediately compete? He said, not immediately compete. You think I was going to become a school teacher? Next. Again, this is Flow Plus. This is how Rockfin held itself out as having the Flow team when it was talking to investors. Next. The subscription media platform, the new model for subscription media companies and creators to monetize their content. That's how Rockfin described itself as it put on one of its first live wrestling events in September of 2019, just weeks before it came to this court, and said that it was not doing live events. Next. The testimony about competition was consistent. If there is wrestling content of the kind that is on Flow Sports, then it is competition, because you can buy the same product at two different stores. And if you can buy the product at two different stores, then it's competition. Even Mr. Floriani testified that the channels themselves are competing with Rockfin, but he wanted to distinguish that, even though the channels themselves there's only 120 of them, you have to apply and you can be ungiven your rights. He wants to distinguish that by saying he's completely independent of that content. Certainly that's not true with Willie Saylor, if it's true with any of the providers. Now, the next slide will show you that how different they are. We've gone through this with a number of witnesses to show the differences between Rockfin and platforms like YouTube or Twitter or Patreon, etc. But they provided studio equipment. They helped create a brand, a signature. They pay for ads for Willie Saylor. They tag him in posts. They paid his health insurance. They indemnify him from attorney's fees, and they require pre-approval to start publishing, and they can kick you off, like I said, if they don't like the curated user experience. Next slide. Also, we know that that Rockfin obtains a license from folks who post on there both video and non-video content, like Willie Saylor's. So a distinction about whether they have a license to this material is a distinction without a difference, because it's right there in their terms of service. Next. So with competition, here we have Flow Sports, and we have something like Disney. And Disney has ESPN, but it also has The Little Mermaid and all sorts of other content, right? Where they overlap, that's where competition is. Next. Here we have YouTube, and you can keep going. And others like MLB and Rockfin. Rockfin, that has a majority of wrestling content, is directly competing with Flow Sports when it's doing that work. Now, you heard Mr. Walk testify that competition is analyzed from the perspective of consumers and media rights holders, which both of these companies target. From the consumer point of view, which is something that he analyzes regularly on a macro level, does Rockfin look like an alternative to Flow Sports as a place to be part of the wrestling community consuming wrestling content? Does it look like a place where your $10 a month can go instead of your $150 a year can go to get wrestling content? Now we know that's where they can get Sailors content, Sailors rankings, Sailors recruitment. From the point of view of a media rights holder like Nittany Lions Wrestling Club, does Rockfin look like an alternative way to monetize its wrestling events? That's exactly what Nittany Lions did when it chose Rockfin over Flow Sports to monetize its wrestling events. And it got paid, as you know, in Ray tokens. Now, let's keep going to the next slide. There's overlap in the subscribers, right? There are people who are subscribing to both Rockfin and Flow Sports, super fans, right? But of course, competitors like Netflix and Hulu have similar numbers. And Mr. Floriani admits that those are competitors. Next. Next. As we talked about with the rankings coming off of Flow Sports and going on to Rockfin, such an indicator of competition, the same content, asking people to subscribe and pay their money to someone different. Mr. Saylor admitted that he deleted work off the site. Go ahead. And he then went and did this video where he talked about confidential information that he had from Flow Sports about coaches. Next. And he admits that he told Mr. Piles that he gave back those rankings. He had taken them down off of Flow Sports content management system. Thank you. Now, same or similar duties is an important part of the contract. And the only duties that Mr. Saylor is not doing right now are the ones that go directly into the teeth of your temporary injunction. He's testified that the only thing he thought the temporary injunction kept him from, despite the way that it's actually worded, is from videos. And so right now he hasn't been doing videos, but certainly he breached that at the beginning, and he's breached all the rest of it throughout this entire time, even in violation of the temporary injunction. Next. Mr. Saylor, again, when not through the filter of litigation, honest about competition. He says that he gave Flow Sports a huge amount of its successful content staples, and that they will not grow. And when they lose the first big contract, they will be in serious peril. The ship is sinking. That's what competitors say. Next. In fact, and you've seen this testimony, you asked this question. He admitted that he would rather people follow him to Rockfin. Next. This is a Rockfin ad that's in evidence on the right, and it's F992. And Rockfin says, experience exclusive video, podcast, live stream, and rankings content on the go with the Rockfin app. Of course, all of those, you could have the exact same ad for Flow Sports. It's one for one what they're getting when they pick Rockfin here. Next. We talked about live streaming, and Mr. Floriani admitted that any part of these three steps was the definition of live streaming. He also admits that at least number 3 is what he does on Rockfin when Nittany Lions Wrestling Club uses his live stream video player. That's F007, where he talks about his live stream video player to distribute that video like an exclusive live event on Flow Sport on Rockfin. Go ahead. And again, that came directly through Willie Saylor, who got the first call. Next. And it was exclusively on Rockfin, and you had to pay and go through that process in order to see the event. Next. These are the kinds of confidential information. Yeah, you're going to want to make sure I'm not using that. Confidential information that Mr. Saylor took in breach of the contract. He took third-party information about coaches and others. And there's a particular provision about third-party information in the PIIA. confidential salary information that he tweeted out, terms of agreements, attribution data that he used to say, target these events and these providers, and they will be easy targets for Rockfin. And they were folks who worked with Flow. He also took rankings and recruiting data. And he admits that he agreed that his non-compete would be extended if he violated it. Go ahead. Mr. Saylor also misappropriated trade secrets. And the first question in trade secret case is the existence of the trade secret, right? Go ahead. In a trade secret, this is in the Uniform Trade Secret Act, the Texas version of it. It specifically includes compilations. And this is where the spreadsheets are so important. Compilations are delineated in 134A.002 in the definition of trade secrets. Next. And there are cases on this, not surprisingly, including a 2018 case where the court said that business compilations can be trade secrets when work that is done is not generally known or available if it provides a competitive advantage. And so even compilations of publicly available data are appropriate or can be protected as trade secrets and should have been protected here, but they were not. Instead, they were used and they still are being used by Mr. Saylor today. Go ahead. And that gave him the kind of head start that he could launch right away and post new rankings on Rockfin in direct competition with Flow Sports. This is something that was 8 years in the making, while Mr. Saylor's job was to sit in a chair, go to wrestling events, and do general coverage for wrestling coaches, wrestlers' parents, and accumulate that data. That accumulation of data is the trade secret. Go ahead. Now, each tab has there are tens and tens of spreadsheets and thousands of data points in each one. Mr. Saylor also admitted that. Not something you could easily just recreate. And if you were going to, I would ask, why would you recreate 60 some odd spreadsheets from scratch? I think it would be, number one, impossible, especially with the anomalies that you saw in the data where a different font was the same in both sets. That just plain did not happen. Let's go to the next slide. And he was paid to do that. And now he's using it for a competitor. Go ahead. Mr. Saylor admits that he got into Periscope after he left Flow Sports. And just days before, he had downloaded the comprehensive subscriber attribution dashboard. This is important because if you access without authorization, you don't even have to show use. Just access under TUTSA is sufficient if it's by improper means. This is after he had quit and decided to go to Rockfin. Go ahead. And now misappropriation of those trade secrets. Go ahead. This is November 4th, the day after Mr. Saylor decided to go to Rockfin. And he takes a picture of some equipment that he wants Rockfin to replace because he had similar equipment from Flow Sports. He takes a picture of it and he inadvertently takes a picture too of his screen. And his screen shows that these very spreadsheets, dozens of spreadsheets, more than 60 spreadsheets are open on his computer. Surely he did not create those within that 24 hours. Instead, he's using them to create new rankings or to update his rankings for Rockfin. Go ahead. Go ahead. You can skip these two. Okay, what you just saw briefly there were two sets of rankings. One was from Flow Sports Google Suite, and one, or ranking spreadsheets, I'm sorry, I'm not making a good distinction there, but two sets of ranking spreadsheets, one from Flow Sports Google Drive, and one that Mr. Saylor downloaded and reproduced to us in February of 2020. And they are the same. In fact, Mr. Piles has testified that F401 is exactly the same, the world's, and Mr. Saylor testified to that too. He said that's on Flow Sports Google Drive, but he had no explanation for why he had it in February of 2020, and his previous testimony had been that he was accessing them and using them in his rankings data, which only makes sense because, like I said, they even have the same anomalies and same mistakes. Now, with this document is F893. What this shows is that Mr. Saylor sent, from time to time, like we all do, sent business data. Here it was the depth chart, business data from his personal Gmail account. And when Mr. Saylor did that, he did not return those documents to FlowSports. Still today, he has not done a thorough search of what he has in his personal Gmail that belongs to FlowSports. Instead, we got this one document in Discovery. You also heard testimony from Mr. Saylor that when he came up with these big leads, he literally cut and pasted from those same spreadsheets and put them into, and we've graded them out so that trade secrets aren't displayed, but cut and paste them into emails to Mr. Floriani to talk about big leads that he would like for Rockfin to pursue. Next. Again, this is another one of those examples where he's talking about an important lead, and he's giving it to Mr. Floriani when he left FlowSports. Now let's talk about tortious interference. It's important to note that you've heard some argument that Rockfin cannot tortiously interfere because it had a misunderstanding of the legal import of the document itself. And of course, that's not the law. All you have to do is desire the consequence of your act, not have an understanding of the legal import of the contract itself. Next. In fact, this line comes from the iconic Texaco versus Pennzoil case, and it's based on the restatement, but it's not necessary that you appreciate the legal significance of the contractual duties. It's just that you take the actions that cause the consequences. Here, the actions are when Rockfin aggressively pursued Mr. Saylor, which Mr. Floriani has testified to, that then Mr. Saylor on October 23rd says, let's do it. I'll get the NHSCA contract and several other big ones. They will sue us, knowing that they would be sued because of the non-compete, and they say they're good on that. Next slide. Not only is there, let's talk about the recruitment in particular. There's three kinds of tortious interference I'd like to talk about: recruitment, promotion and involvement, and profiting. And so on the recruitment side, Mr. Saylor said that he needed to have a salaried position at Rockfin, and that's what he got. Next. This is that same F002. It's the flywheel email that they exchanged in February of 2019. And Mr. Saylor admits that Rockfin pursued him for a full 9 months. Next. Mr. Floriani told him that he wouldn't be able to do both at the same time. That's the language in that provision is exactly the same as the language in the non-compete. Go ahead. And Mr. Floriani aggressively, like I said, aggressively pursued him. That's his own words, aggressively pursued him. He said he also said he unequivocally had salary potential long-term at Rockfin. Next. This recruitment started in February of 2019 and kept on going in May again. Next. And then finally in October, when he found out that Mr. Saylor had decided to stay in Pennsylvania and not go to UNC. Next slide. Throughout, despite the model that Rockfin purports to have, Rockfin has paid to promote and been involved in Willie Saylor's content on Rockfin, and they've certainly handsomely profited from it. These are just some of the many ads that Rockfin has run for Willie Saylor's channel, Mad Scouts. And by the way, Mad Scouts is not a legal entity. It's just Willie Saylor. And they've paid that by targeting Flow Wrestling audiences on Facebook. In other words, they've bought those audiences, they've targeted those audiences. That's competition, and it's also tortious interference. Next. Mr. Balaket testified about that very thing, about the targeting, and you can tell in this particular targeted ad, the young man even has on a Flow Sports singlet at the time. Next. And Rockfin is profiting. Next. As we talked about, the flywheel worked. I mean, they've made I'm not going to talk about the specific amounts of money that I will update the court on that later, but based on the testimony and the exhibits that came in the private session, it is a very, very significant amount of money, more than Flow Sports damage model in the entire case, off of this work from Willie Saylor alone. From Willie Saylor alone. Okay, next slide. Now, the one groundless claim in this case is Willie Saylor's stock option claim. He testified that he had absolutely no evidence that the board abused its discretion or did anything wrong. And the board had full discretion, and the board had in hand a temporary injunction with a finding of likelihood of success. Next slide. Let's talk briefly let's talk briefly about damages. I think we took out what you're talking about. So let's go to the next slide. That's not AEO, is it? Okay. And this is a summary of Mr. Jordan's damages that he testified to and totaled up to $728,000. And then you can skip past the next one. Okay, yes, I thought I took that out. I just wanted to make sure that I didn't put anything in there that would be considered problematic, but we'll submit the number on the disgorgement unjust enrichment to the court based on the admitted evidence after the closings. But there's lost profits, there's disgorgement or unjust enrichment, which are proper on both the tortious interference claim and the uniform trade secret claim, attorney's fees, which has not been presented yet, and also continued injunctive relief. And with that, I would reserve whatever time I have left. I haven't heard you say that you're ready for me to stop talking, but I will do it anyway. And I really appreciate the court's indulgence and the time that you've spent with us, especially with all the challenges of being in a Zoom context. So thank you, Judge.
Your Honor, can you see my screen? Okay. Flow Sports' story in this case hasn't changed even with the introduction of evidence in this trial. And it's not surprising that they're glossing over the actual language in the PIAA in their closing argument, because that's the language that you have to interpret with the evidence that we have presented and that has come in through this trial. And that evidence shows that the PIAA was actually not violated, which is the first element in the existing claim against Rockfin in this case, which is tortious interference with the contract. The other three elements, on those three, plaintiff has also not met their burden, in fact, fallen well short, and I will go through each of them for you. So there's three provisions of the PIAA that plaintiff is saying Saylor breached. He hasn't breached any one of them. The first is a non-compete. There are three Romanettes in the non-compete. The first one prohibits Saylor from competing with Flow Sports in the region or cities in which he was responsible for conducting business. This is the broadest one. In this litigation, Flow Sports has taken the position that they have a broad array of competitors, but that hasn't been the case outside of the litigation. Outside of litigation, the reality is that Flow Sports is a live events streaming company, and Simply, Saylor does not compete on that level with Flow Sports by posting wrestling journalistic content on Mat Scouts, which is a channel on Rockfin. So the evidence that you've seen in this trial that Flow Sports competitors, the type of business Flow Sports is in is as follows. The CFO, Pat Noonan, testified that Flow Sports' core business is live event streaming. And he said that live event and video content coverage is Flow Sports' primary offering. He also testified that Flow Sports represented to investors in its Series C and Series C fundraising rounds that its competitors are anyone who competes for the live rights to sporting events. And Flow Sports head of data analytics, Mr. Davis, testified that Flow Sports' higher churn numbers in 2020 are owing to the lack of live events due to COVID. The former director of digital marketing at Flow Sports, Mr. Velaquette, testified his primary responsibility when he was at Flow Sports was to market live events, that those drove 80 to 90% of the signups. One of the 6 pre-populated reasons that subscribers can select when they cancel their Flow subscription is that they haven't found enough to watch, not to read. Mat Scouts, on the other hand, does not compete for the live rights to sporting events. Mat Scouts produces rankings and articles, and before the temporary injunction, podcasts, which, as Mr. Machuca, Flow Sports corporate rep, testified, that type of programming merely hypes and creates excitement around the live events. In other words, Mr. Saylor is a promoter. What he does is promotional activity. Similar to the Wrestling Nomad, who offers similar content on Patreon. Mr. Wolk, Flow Sports expert, testified that it is possible that the Wrestling Nomad's content would actually help Flow Sports by creating buzz around the live events. Rockfin also doesn't compete with Flow Sports for the rights to live sporting events. Mr. Windler, Flow Sports head of rights acquisition, testified that they have NDAs and confidentiality provisions in all their agreements with rights holders. But Rockfin doesn't even sign agreements with rights holders. And they didn't sign one with Nittany Lions Wrestling Club. And that's because Rockfin is a content neutral technology platform that allows content creators and media companies in a variety of subject areas to distribute their own content on their Rockfin channels.
How long did I talk? 30 minutes. Okay. Oh, wow.
I can
surprised I did that.
I can hear you, Ms. Burgess.
Oh, I'm sorry.
That's okay. Well, now, sorry. Flow Sports has taken the position, and there's testimony in this case, that the difference between Flow Sports and Rockfin is that Rockfin pays creators in cryptocurrency. But that is certainly not the only difference. Aside from the fact that there's no competition for live rights, Rockfin does not control, create, or own the content, despite that licensing agreement and the terms of service does not own the content that creators publish on its platform, and Flow Sports does. There is a clear distinction between a platform and a publisher. Mr. Wolk testified to that. And Rockfin avails itself of the safeguards and protections provided by the Digital Millennium Copyright Act, as well as Section 230 of the Communications Decency Act. Mr. Machuca, Flow Sports rep, who believes everything under the sun is a competitor, admitted that Roku is not, because Roku does not create content. And Mr. Wolk similarly testified, Mr. Wolk, who testified that your honor's hypothetical son, who writes for a high school newspaper, would be competitive with Flow Sports, confirmed that Roku would not be a competitor because it does not create content. And your honor, Rockfin is no different than Roku because it does not create content. In fact, Rockfin is less of a competitor than Roku because Roku actually has a channel on its own platform and Rockfin does not. Both Rockfin and Roku promote the channels that are on their platform. Roku promotes that they have Netflix, etc., and Rockfin promotes the channels on theirs too. As confirmation of this distinction between publisher and platform, you have learned in this case that Flow Sports could have a channel on Rockfin because Flow Sport, but Rockfin has no content to contribute to Flow. To the extent, there's been a lot of discussion about the Nittany Lions Club. And in the case of competition, Flow Sports was competing for the rights to that event with the club itself. Cale Sanderson, in deciding what to do with his event, could have chosen to go with the Flow Sports, who would have paid him amount up front, let's say, for the rights, and have other provisions in a contract that they would have signed, or he could have decided to produce it and find a platform in which to broadcast it. And in doing so, he was making the decision to go out on his own with no guarantee whatsoever of how much money he would make from a Rockfin or a Patreon if he decided to go that route. It was his decision as the rights holder whether to risk it and produce it by himself or take some sort of guarantee. And that is a really big difference. It makes all the difference actually as to who Flow Sports is actually competing with regard to the rights to events. Other evidence that has come in or argument that Flow Sports has made as to why their Rockfin and Flow Sports competes is Mr. Windler's testimony that Rockfin targeted Matt Scout ads to a Flow Wrestling audience on Facebook. Therefore, it was competitive. There has been no other evidence in this case that targeting a Flow Wrestling Facebook audience with Matt Scout's ads shows competition. In fact, Rockfin's VP of marketing testified that he did that because it was experimental and it wasn't successful anyway. And Mr. Wolk, their expert, testified that just because two companies are targeting the same demographic does not mean they're competitors. Use the example tobacco and Ford trucks. I'll give you two more, REI and Whole Foods, sugar cereals, cartoons. Mr. Wolk also testified that Matt Scouts and Rockfin compete with Flow Sports for subscription dollars because they offer similar content. But this expert just studied the websites of the two platforms for a few hours and has absolutely no insight into the point of view of wrestling fans, which is what matters. Though he did admit that there are lots of semantics, he said, about what competitive means, and his opinion might change if he saw the actual numbers of overlap in subscribers. And I won't go into that right now exactly, but Your Honor did see that overlap, and it was substantial. So that's all to say that the argument in this lawsuit that Rockfin competes with Flow Sports is a pretext. And I say that for a few reasons. The SVP of Global Rights Acquisitions testified that it was critical to keep up with the competitive landscape, and therefore Rockfin was on his radar. But he didn't know anything about Patreon, which other Flow Sports employees have testified as a competitor, which Rockfin considers a competitor, which really is not that much different than Rockfin except for the cryptocurrency aspect. Machuca, the corporate rep, he testified that Patreon was a competitor, but he also testified that he told Dan Lobdell, a former content writer, that he could go anywhere, even Patreon, to write about wrestling. He just could not go to Rockfin. Flow Sports knows that Patreon doesn't compete with it because they actually promoted the Wrestling Nomad on their channel. And unbelievably, they're somehow fine with Ben Askren co-hosting the Flow Radio live show. At the same time, he has a wrestling channel on Rockfin. And so, Your Honor, for those reasons, they aren't a competitor. But even if they are, they can only be a competitor under the very overbroad and totally unenforceable definition that Flow Sports has advanced in this case of who they compete with. That is confirmed by both Mr. Windler and Mr. Machuca's testimony, who both testified that any content about any sport or any other competition, and I believe Mr. Noonan brought up a political debate potential is included in that Flow Sports covers or considers covering or has covered in the past is competitive. It doesn't matter if the medium is free or behind a paywall. It doesn't matter if the medium broadcasts live events. It doesn't matter if it's digital or paper. It includes sports video production companies, professional teams, the MLB network, Olympic governing bodies, national print publications that have sports but not video, national and local newspapers, the Austin American Statesman, Longhorn Network, Big Ten Network, Amazon, Facebook, YouTube, Twitter, Netflix, Hulu, Twitch, sports agencies, PR firms, and casinos. It's unreasonable, it's per se unreasonable, and it's overbroad and unenforceable. The second Romanet prohibits Saylor from participating in the ownership, management, operation, financing, or control of any entity providing products and services in the sports video industry. First of all, Saylor never participated in, sports video industry aside, Saylor never participated in the ownership, management, operation, financing, or control of Rockfin. And that is undisputed evidence. He had no job responsibilities as a W-2 employee, a status that only lasted until December 26, 2019. He also doesn't have the same or similar duties he had, again, Math Scouts, whether Math Scouts is in the sports video industry aside, actually, I will go into that. Neither Rockfin nor Math Scouts are in the sports video industry. Now, throughout this litigation, there has been inconsistent definitions of sports video industry advanced by plaintiffs. Their original definition came out on January 30th and across MSJ. They defined it as a business involving recorded images relating to physical games or competition. Mr. Wolk disagreed with that definition. He defined it as, because that would include images and writings, which he says are not video. He defined it as anything that is video. Well, neither Rockfin nor Math Scouts fits into either of those definitions because Rockfin is a technology platform where the channels sit, same as Roku, I've been over that. And Math Scouts provides journalistic content about wrestling. Mr. Wolk testified his articles are not part of the sports video industry. And even though Matt Saylor put up a few podcast videos before the TRO, that is not sports videos either. And to the extent that Rockfin or Math Scouts are considered to be in the sports video industry, it's only because in this trial, FloSports has defined it as whatever the company does. In fact, it could be substituted with onion, they said, and have the same meaning. Mr. Wolk literally laughed out loud at that definition, and as he should, because they have no legitimate business interest in restraining whatever they do. That's confirmed by their promotion of Wrestling Nomad and their allowance of other former employees, including Taylor Dutch, Todd Graysley, the list goes on. In fact, I believe you sustained a repetitive objection to this testimony to do sports journalism after leaving FloSports. Also, FloSports is capable of drafting and has drafted a PIA that expressly prohibits competing with the company in business, which in that PIA, they define as what portions of the company's business the employee participated in. Whether that's enforceable isn't an issue, but the fact is that it's way more broad than the PIA that Saylor signed that says sports video industry. So it can't possibly mean whatever FloSports does. The third prohibition in the PIA was that Saylor was prohibited from performing same or similar duties for a company in the sports video industry. For the same reasons I just discussed, neither Rockfin nor Math Scouts are in the sports video industry, but also Saylor didn't have the same or similar duties at FloSports as he does at Math Scouts. Of course, there's overlap. He wrote articles and does rankings and did that now and did that at FloSports. But he had video production related duties at FloSports. As an MC and as he ran the show for Who's Number One and Flow Nationals, and those duties did not carry over to Matt Scouts. He's not produced anything at Matt Scouts, and neither is he a managing editor or a manager of any kind. He was a promoter at Flow, and now he is a journalist. Your Honor, in the alternative, if you did find that any one of those was violated, and our position is firmly that the plain language of them, based on that, they're not. We would argue that your temporary injunction reformed the covenant not to compete because under Texas Business and Commerce Code section 15.51C, because the limitations were not reasonable as to the scope of the activity to be restrained, and it was greater than necessary to protect the goodwill of Flow Sports, and therefore the TI reformed it, and hence the carve-outs allowing Saylor to write about future sporting events and rank. And where our position is that both parties have adhered to the reformed agreement since the TI was entered in January. But even if they haven't, this provision 15.51C precludes Flow Sports from recovering damages after the covenant has been reformed. Okay, the second provision is non-solicit. Flow Sports claims Saylor solicits, in the petition, Flow Sports claims he solicits Flow Sports subscribers, pitches wrestling coaches to work exclusively with Rockfin. And again, we saw the same parade of evidence, but the truth is that not one single thing that they have shown you today or throughout this trial has caused any damages, which is an element of this claim. Not from Cale's text to Saylor about whether Rockfin could host the Nittany Lions, could work for Nittany Lions. He just referred Cale to Martin. Not from Willie's NHSCA text. There's no evidence that Willie gave the details of that contract to Rockfin, or any evidence that he acted on that text. Not by his leads email where he identified the big one. Flow Sports didn't get. Both Willie and Martin testified they didn't reach out to that guy. And not by the Easy Life targets list, which the evidence actually showed most were hypothetical. And anyway, in response to that email, Martin testified, he called Willie and told him, this is not what we do. And again, the sports video industry language is in the non-solicit paragraph as well. The third one is confidentiality. And as it relates to Rockfin, Your Honor, the amended petition states that Saylor shared confidential information with Rockfin. I can only assume that that's the same information, that's the same stuff I just went over, which is the Easy Life targets list and the leads email and the text about NHSCA contract. And there is no evidence that Flow Sports was damaged by any of those communications. Flow Sports has also not proved that there's been a willful and intentional act of interference. They claim that there are three. One, soliciting Saylor. But Martin Floriani solicited Saylor to create a channel on Rockfin aggressively. As Ms. Burgess pointed out, his testimony was after he learned Saylor had quit Flow Sports to go to UNC, meaning that it wasn't a willful and intentional act. From February to November, the testimony surrounding that first email where Saylor pitches Martin on going to work for Rockfin, the text confirmed these two old friends were just talking about opportunities. Martin was not actively soliciting Saylor. In fact, there's evidence that he at multiple occasions told him he was not the right fit for Rockfin, and internal documents confirm this. The second act of interference advanced by Flow Sports is marketing the Matt Scouts channel. I don't fully understand how that marketing that occurred after Saylor left is interference, but one of the claims is that they marketed Saylor using Big Board and Greatest Mind in Wrestling. Though their corporate rep admitted Big Board was not a moniker created at Flow Sports, and you saw evidence that Rockfin has not used the Greatest Mind in Wrestling since December, before the TI was entered. Moreover, With respect to marketing Sailor to the Facebook audience of users who like Flow Wrestling, you heard from Rockfin's VP of Marketing that this audience has a about 10% overlap with people who actually subscribe to Flow Sports. And you also heard that the marketing wasn't successful, that it was double the holistic cost per acquisition of targeting other audiences, and also that the audience hadn't been targeted since January 11th. Also, there's no damages from this. Second, there's no willful and intentional active interference because of our affirmative justification defense. The black letter law is that if there is a good faith claim to a colorable legal right, even if it proves to be mistaken, that is an affirmative defense to tortious interference. And that's what we have here. Martin, who countersigned the PIAA, did not believe that Sailor having a channel on Rockfin would be in violation of the PIAA. And that's because he knew where the language sports video industry originated from. It originated from a PIAA signed by Adam Finn when Flow Sports purchased his company, Wrestling Video Solutions. When they purchased that company, they had him sign a non-compete to protect the newly acquired technology by Flow Sports. And that language found its way into the PIAA signed by Sailor, which made sense because he had production-related duties as the MC, broadcaster, guy who ran the show. He testified he overhauled production-wise to Flow Nationals. And further, Martin knew Flow Sports had never enforced the PIAA against journalistic pursuits. So he had a good faith belief that soliciting Sailor in early November 2019 would not be violating the PIAA, which was more than a colorable legal right. There is no credible, on the third prong, that proximately caused plaintiff's injury. There's no credible evidence that anything Martin did caused Sailor to quit Flow Sports. Sailor testified that he quit his job this final time in response to a blow up between himself and Kyle's over a tweet, "What's going on in Ohio?" He also testified he didn't know when he quit he was actually going to go to Rockfin. He didn't think the termination would stick. He testified that it wasn't until after he learned Flow Sports had shut down his access that he officially decided to launch a Rockfin channel. And he testified that it was inevitable that he would leave Flow Sports. So there's no clear evidence that the solicitation, so-called solicitation, proximately caused plaintiff's injury. And finally, there is the damages evidence, which Your Honor heard today, is entirely speculative. The lost profits can only be recovered when the amount is proved with reasonable certainty, and it can't be speculative, but it is here, and that's because it's based on far too many flawed assumptions. I'm going to try to do this without going into AEO information, but in the first bucket of damages, the lost subscribers, that number, the number of overlap of people who left Rockfin, left Flow Sports and joined Rockfin, includes people who canceled their subscriptions for reasons totally unrelated to Willie Sailor, including people who canceled for the reason temporary, I'll be back, I haven't found enough to watch, too expensive, free response answers that included the persecution of Willie Sailor, suing one of your employees that left, and billing issues, all attributed to his departure, which is flawed. And also, it includes subscribers who quit Flow Sports and then joined Rockfin months later, which is speculative. That one, the causation is speculative. The second bucket, that's flawed for similar reasons. It was based on the same cancel reasons, and but we did learn that the number of people who are Flow Sports subscribers, if they are also a Rockfin subscriber, they are more likely to renew their Flow Sports subscription, which shows how complementary the two companies are. And finally, in the final bucket is speculative, because it's based on the idea that Mr. Saylor would have stayed at FlowSports for 4 more years, which every piece of evidence in this trial shows would not have happened. That he was looking for another job. He quit UNC. He said his soul was being sucked by being there. He was on a performance improvement plan. He testified his resignation was inevitable. Mr. Machuca wanted him out, urging his manager Piles to fire him on several occasions. And you know, it's also, this third bucket is also based on the fact that it assumes no one could replace Saylor. They take this position at the same time that they argue that they made him who he was by sending him all over the world and all of that. And they take the position at the same time as arguing that they did try to replace him. But I guess the damages theory is just based on the fact that they gave up. And that is not proved with reasonable certainty. And as to this unjust enrichment claim, which we saw in the 11th hour, we don't believe it's proved. We don't believe that Rockfin profited in any way from Mr. Saylor, and certainly not in the amount that's greater than the damages expert theory. So anyway, because the argument hasn't been made, I can't respond to it now, but I'll head it off by saying that. And Your Honor, what we're asking here, we don't know the status of the temporary injunction. I think the parties agreed to extend it through our last trial date, which was September, but we would ask that it be dissolved, that plaintiff take nothing. And we are asking for our attorney's fees for defending against the Tutsa claim against Rockfin, which was brought just before the TI hearing and dropped just after we served discovery, asking for the basis of that claim. But I understand we're taking up attorney's fees at a later date. And with that, I thank you. This has been an honor to have you as our judge.
All right, thank you very much. We've gone over almost, well over an hour. I think what I'll do is give the court reporter a break, and we'll finish up with the argument by Mr. Soltero and then the final argument by Ms. Burgess. But she won't be able to make it through the rest of those two without a break. So we might as well break now. Let's give her, let's come back at 4:30. We'll be in recess until then.
Thank you, Judge.
You're welcome. So I sent Lasagna an email. I wasn't sure if
I'm thinking I'll probably stay on. And
Okay.
so the break
Can I put you back in the?
The case, the CF case that's here, performance pulsation control, that's not from Austin, right? I need to- I'm gonna make it through this trial.
Waiting on Miss Duet. Oh, there she is. Okay.
Let me know when you're ready.
I'm ready.
All right, Mr. Salt, is everybody that needs to be back? Yes, we have somebody from every, well, I don't see Ms. Burrs. There she is. All right, Mr. Soltero, you may proceed.
Thank you, Your Honor. May it please the court and counsel. It is my privilege and honor to represent Willie Saylor. This case remains today what it's always been, a case about corporate bullying. This case is motivated by vendetta and has been made as expensive and time-consuming as possible. I have a PowerPoint, Your Honor, that I would like to share to go over some of the evidence.
Speaking of PowerPoints, everybody has used one this afternoon. Are you planning to send those to Mr. McCabe for my benefit afterwards? They're not going to be evidence, obviously, but just for your demonstrative, this might be helpful if everybody just sends theirs to Mr. McCabe. Okay, go ahead, Mr.
Yes, Your Honor.
Soltero.
Yes, Your Honor, I will submit it to the court. And can Your Honor see it okay?
Yes, sir.
Okay. So again, let's put the framework around the case from our perspective. There are two claims against Mr. Saylor, the trade secret claim and the breach of contract claims. The trade secret claim, Your Honor, and I do not say this often, but this was never a good faith trade secret claim. This was such a bad claim as to Rockfin that they even non-suited it after the injunction. But as to Mr. Saylor, this has never been a good faith claim, and I'll explain to the court why. In addition, there's the breach of contract claim, which, as Your Honor knows, has been the reason why Mr. Saylor has been enjoined. That's their remedy. As Ms. Klingsheisen pointed out, 1551 provides them that remedy, and they've had it. So the other claim, which Ms. Burgess took issue with, is a very simple case, Judge. And there's not much, you haven't heard a lot of evidence about it because it's pretty straightforward and simple. What happened is that Mr. Saylor was promised stock options by Flow Sports, not at the time he signed the PIIA, but 2 years later. And then they took it away from him. They just basically took that part of his compensation away from him. They retaliated it because he went with Mr. Floriani's entity, Rockfin, to start his Mad Scout channel. And so there are several legal theories which provide him the remedy to get the value of that. One is breach of contract, because there's a contractual provision that's in evidence. The other is fraud in connection with stock, which is what this is, stock options. And the third is just simply promissory estoppel, unjust enrichment. And Your Honor, the documents that are already in evidence that we don't need to read to you, that we don't need to spend a lot of time on, show that these were granted and then the board unanimously took them away from him on January 10th with no justification. And you heard Mr. Machuca say, never done this to any other employee, and that this is an extraordinary thing. And you know that there's been a fair amount of misconduct involving some of the people there, and it never led to something like this. So to put the frame on the facts and the timeline, and Your Honor, you may remember that I brought this up at opening, so at closing, I'm coming back to where I sort of began in a way, but now with the evidence as it's come in. Your Honor has now seen the evidence of the conflicts between Mr. Piles and Ray Machuca on the one hand, and Mr. Saylor on the other. And this is one of the weirdest things you can imagine. He's put on a performance improvement plan. But there's absolutely nothing wrong with him. And he's so-called irreplaceable. He is the irreplaceable Willie Saylor. They can't replace him, but yet he's on a performance improvement plan that they can't describe why. And the reason is because he speaks his mind, because he speaks things in a way that's perhaps unconventional, that causes some friction, and that certainly some people who I guess Flow Sports has business with don't appreciate some of the things that he said. And it certainly explains why that was not a good long-term situation. Your Honor has heard the evidence that he was offered a great opportunity at the University of North Carolina, and he initially took it, but then changed his mind, decided that's not what he wanted to do. He came back, and then eventually he again quit after the "what's going on in Columbus" came up, which is an honest, fair criticism in the world of sports to complain about a program that in somebody's perspective may be underperforming. There may be good reasons for that. It may be wrong, but it was a sincerely held opinion that came back and backlashed with him having that confrontation with Mr. Piles. The evidence is clear. Mr. Saylor said, that's it. That was the straw that broke the camel's back. With regards to all that, Your Honor, I would just remind the court that if Your Honor wants to go back and look at the evidence in detail, Defendant's Exhibit 102 provides those texts in detail. In addition, and I'm going to go into this a little bit now, Your Honor, to refresh what the evidence has shown, it's clear that when Mr. Saylor resigned that night, very shortly thereafter, within a day or so, all access was cut off. And I'm going to go through some of the evidence. Oh, and by the way, all this should have been the end of the case after the injunction. In most of these cases, there's an injunction hearing, the parties work it out, it's over. But that's not really what Flow Sports wants this case to be or what this case is about. And so here we are, a year later, still going over these things. But this is critical, Your Honor. Defendant's Exhibit 25, as we went over the evidence, it couldn't be clearer. Mr. Piles telling Mr. Machuca that Mr. Saylor quits and it's got to be the last time. They've gone through this so many times that this has to be, as he says, the final decision. And then within 11 minutes, Mr. Machuca sends an email to all those people over at Flow Sports saying, cut them off. We know that within hours, and certainly by the next morning, Mr. Saylor is off of his G Suite, passwords, and I don't need to read to Your Honor knows and has seen this. And there's another exhibit, Defendant's Exhibit 26, that also has another list of things he was cut off from. And then tellingly, Mr. Aubrey Davis, who Your Honor heard from here in this court, who is a technical person, came back and told Mr. Machuca on November 24th that as of November 3rd, he'd also been removed from Periscope, which Your Honor will remember is the 2017 introduced information that they believe is highly confidential and has all these things. So we make the extraordinary ask, but exactly what the legislature has created this provision for is this case, and this type of case is for us to be able to recover our fees when somebody who is in a situation like Mr. Saylor has to endure the kind of litigation that's been thrust upon him that was not brought in good faith. And so the Texas Uniform Trade Secret Act specifically allows for Mr. Saylor to recover because this claim of misappropriation was made in bad faith and the resistance to the injunction being dissolved was made in bad faith. Why do I say this? This is a tall order for me to be saying this, but it started from the very beginning. The affidavit of Ray Machuca, and it is unusual for me, or I think for most lawyers, to put in the other side's sworn statements as an exhibit. But I had to do it, Judge, because this is the declaration that on December 18th was filed with this court to get temporary restraining order that eventually became a temporary injunction. And it was made on statements that were at best misleading and factually inaccurate. And I went, as Your Honor will recall, with Mr. Machuca, literally paragraph by paragraph, showing where the things that Mr. Machuca swore out were inaccurate. And most of these things, they either knew were inaccurate at the time, or they had no reason one way or another to be making these statements and shouldn't be coming into court and saying these things. So where do we find this in Defendant's Exhibit 22, and what am I talking about? Number one, they know that Mr. Saylor had no access to Periscope. That he had explained that he went back and looked to check his bonus calculation the next day. It had been completely shut off. There was no fear whatsoever that he was going to get into their systems and get anything. And ironically, Mr. Piles shared some of this Periscope data in a text with Mr. Saylor 2 weeks later because he was talking about the bonus and the attribution or what have you. He had no access to Stripe, which is another one of their databases. And Mr. Machuca made the absolutely false statement that Mr. Saylor had 5,000 subscribers. That was never true. Wasn't true then. It's not true today. You heard testimony from their experts say he knew it wasn't true and there was no evidence to support it. The 175 screenshots, mostly publicly available information. They came to this court and said, big old trade secrets. He's taken all these screenshots. They were publicly available information, screenshots of texts. You've seen many of them in this case, nothing that is a trade secret. There has been absolutely no downloading by Mr. Saylor, as they've alleged. And I'm going to talk about the spreadsheets and all that in a little bit. And then the timing of the stock options, which is highlighted here on paragraph 4 of Exhibit 22, is that it is very misleading to be putting in there that all these things happened in 2014 and that Mr. Saylor was awarded these very stock options that they then took away from him in 2020. That did not happen in 2014. That did happen in 2016. And I'm going to talk about consideration in just a little bit as well. So what other evidence? It didn't stop at the TRO and the TI, but certainly things around that include this bad faith that's been happening from day one. They hacked into, this is something I do not see often and I think is outrageous. It's understandable that an employer would go into an employee's computer and look at things that they had on their system. It is not understandable and it's not okay for them to have gone into Mr. Saylor's personal Gmail. If there was no access to the internet, if they just looked at his desktop, they would not have had access to that. They literally had to go into internet accessible, his Gmail drive using his passwords, including communications with a lawyer that was initially involved in this case before my current co-counsel and myself were hired. And that's in Defendant's Exhibit 89 and 90. So what else evidences this trade secret claim being brought in bad faith and why we're here and why we're going to ask for our fees? They then used R3, a very well-known reputable forensics group, to do some of this apparently. As soon as we tried to get the information, they de-designated him. Your Honor granted a motion to compel, and they hid the person under the consulting expert privilege and never got that information. In addition, their construction, and Ms. Klingsheisen went into this in great detail, and I don't want to repeat a lot of her very accurate arguments on this, but I'll just note their construction of the term sports video industry really is absurd. And it's the reason why 1550, 1551 has the parameters that if these restrictive covenants have to be narrowly tailored to what's a reasonable goodwill of a company, and they are not. And as Ms. Klingsheisen noted, Mr. Machuca would have substituted the word onion as being the same thing to show how wide they basically wanted to do what's called an industry-wide exclusion, which Your Honor knows is prohibited under Texas law. I've already mentioned that they retaliated against Mr. Saylor by taking his stock options. That's also in Flow 884. And we know the motivation is this bad will and vendetta against Mr. Floriani. I'll continue. There's more. The treatment of the other people who have left is reflective of what their legitimate claims, as opposed to their molehills into mountain claims that we have in this case, is that Nomad on Patreon, Mr. Williamson of Grow Wrestling, Mr. Ben Askren, who is on both Rockfin and Flow Sports with apparently no objection from Flow Sports. And there are a number of other examples that we brought up to Your Honor of other people who are content persons and who Flow Sports has not tried to enforce this huge industry-wide exclusion upon. There was attempts to contact the court staff ex parte after the injunction hearing to get a clarification of a ruling. Then there was the dissemination of false information about Mr. Saylor. There was the whole Ray tokens issue, and I'm not going to get into the details other than to say that Mr. Piles was communicating confidential information that was attorney's eyes only to Mr. Bader and Mr. Askren. And as Your Honor remembers, he said, well, it's ironic since their complaint was that Mr. Saylor had allegedly tweeted confidential information. And they've called him somebody who's stolen trade secrets from them, that he's a thief. What we've seen in this case is a very clear example of crying wolf. Time after time, we see humongous volumes of paper brought to the court. Your Honor indulged everybody in this case and gave us 2 full, whatever it was, 2 days worth of hearings on a contempt hearing, on a so-called emergency, and on and on. And it's just been a pattern of harassment to Mr. Saylor. So what the bottom line is, a defendant, there's no trade secret violation here. There was no improper acquisition. Remember, Ms. Burgess objected when I asked this line of questioning, but it's in the statute. There's no bribery, theft, espionage. Everything he got while he was an employee there. No doubt that he didn't take any trade secrets with him. There's dubious identification of any real trade secrets. No access after he was cut off on November 3rd. And really now we're getting to the core dispute here, Your Honor, is general knowledge. Law is clear, both pre and post TUTSA, that the general knowledge, experience, and skills of an employee, even if acquired during the employment with the plaintiff employer, is not a trade secret. They cannot own his brain, which is what they're trying to do. And Mr. Machuca acknowledged on page 94 on November 9th, here in this court again, that's what makes Mr. Saylor valuable, is his brain, not anything else that you may have or have looked at. There's no evidence of commercial misappropriation or misuse. And frankly, Judge, there's no damages whatsoever on their trade secret violation. It was a bad faith claim. It's never borne any fruit, and it should be thrown out. I want to explore a little bit more about what they're claiming he, quote, misappropriated. Number one, the Periscope data. We know that he didn't have access to it. I'm not going to repeat myself again. Number two, the Ben Askren tweet. And I've shown the redacted version here, but Your Honor has seen Flow 810, where he doesn't have any salary information. There's no numbers. It's a pretty generic tweet. And as the damage expert has testified, absolutely no damage is caused by any alleged tweeting. Third, the confidential information or analytics. We took Mr. Machuca, the corporate representative's deposition. No evidence that he exported these off his laptop. And number four, rights holder or customer data. There have been no live events that Flow Sports has lost because of Willie Saylor. And Mr. Machuca tried to fight me, and Your Honor remembers that I was impeached him on that very issue. So let's talk about some other things that have come up in the case, Your Honor. Rankings. We've heard a lot about rankings. It's important. But rankings are public. They are publicly shared on the internet. They are opinions. They change all the time. Your Honor even asked questions from time to time. There is no secret sauce or algorithm for rankings. Mr. Saylor bases rankings on his opinions and his encyclopedic knowledge of wrestling and following the sport closely. They're totally subjective. There's nothing that he took from Flow Sports to do these rankings. And then I want to talk about the November, when this case started. He had been working on some rankings. He pulled them down. He was upset. He then went, and when he was on Mad Scouts, he put new rankings, which actually Flow Sports copied and put up on the Flow Sports website. Mr. Saylor had given Mr. Piles where they were located on the system, the ones before they had been updated because an event occurred after Mr. Saylor left. They could only have been copied from what he had posted on Mad Scouts rather than the other way around. But more fundamentally, Judge, what is special about weight class and rankings? What is special about the particular information of where somebody goes to school, et cetera? Nothing. These rankings become stale quickly and they're limited value. And then I'd also point out the Kate Olivas cross-examination, Your Honor. Mr. Piles had the audacity to come and tell Your Honor that if there's somebody from the beginning who starts out as a wrestler, they're always going to keep going as a wrestler no matter what through their class. The Kate Olivas was just one example of people who, for any number of reasons, may quit, and why this stuff is not what they contend it is. Not only are the rankings not trade secrets, but these spreadsheets are not trade secrets, okay? The testimony from Mr. Saylor is that he has been compiling information that is publicly available since before he went to Flow Sports. He's had all kinds of spreadsheets. What he also testified is he never accessed Flow's data when he left, that it's his personal work. And this thing that they've tried to make a big deal about and confuse, this December 2019 spreadsheet, was something that had, as he says, nothing to do with Flow Sports, like zero. And so this is a no good deed goes unpunished situation. Mr. Saylor turned the keys over for us to do a wide sweeping response to their broad discovery requests. Things were produced, and that explains why things were produced in February of 2020. Has nothing to do with any alleged misuse of trade secrets or misuse of these spreadsheets. And they even took the position that they weren't going to contend that these spreadsheets were trade secrets when we forced them to a motion to compel. And lastly, it's without question that none of that was used. So let me move on to the second claim against Mr. Saylor, the non-compete allegations. The cornerstone or touchstone of this, and Your Honor hears these all the time, so I will not belabor the point, but it is reasonableness. Restraints have to be reasonable. Time, limits, scope, and geography. This is a complete overreach. And as Mr. Machuca testified, they intended this overreach back in 2014. Clearly, there's no geographic restriction. Texas law will allow a substitute for that in certain circumstances if you limit it to particular customers or have otherwise reasonable limitations. This does not. Their interpretation is an impermissible industry-wide exclusion as specifically intended by Flow Sports through its corporate rep. And I would suggest to the court, when you look over the evidence, you can look at November 9th, page 63 and 64. In addition to that, Ms. Burgess has taken issue with me from time to time because I've raised the consideration issue. Well, there's the Sheshnoff case, which we're all familiar with, but there's also the issue of inadequate consideration. And what we have here is it's without question that the evidence is undisputed. In 2014, he got no bonus, no salary, no promotion, no additional benefits, and no new information. The so-called confidential information he had been getting without a PIA for 2 years before they brought this document to him in 2014. The fact that some of this that he may have gotten confidential information later, I think is inadequate consideration for what they're trying to impose in this case. And because of the equities, it's particularly so. Everybody in the world is a competitor. Your Honor mentioned a high school writer. That's an example of how broad they want to do this. And Mr. Saylor was not going to sign that document when they brought it to him. Ms. Burgess showed in the PowerPoint earlier. The office manager came by a couple times to talk to him. He wouldn't sign it. So what does he do? He goes to the CEO of Flow Sports and says, I'm not going to sign this. And his interpretation and understanding was that all this had to do with was not live streaming or video for a year. And he's complied with that, certainly since the injunction. Non-compete, one of the things I'd bring up, Your Honor, the end of his separation from Flow Sports is telling. This is part of that tweet, that text where he's going back and forth with Mr. Piles. He says, final straw, I'm out after the Ohio State thing. This tension had been building and he left to do different things, not to just promote Flow Sports, but to give his honest opinions about wrestling and that sort of thing. Mr. Saylor is and you've heard this several times, so I'll go through it relatively quickly, but I think it's important now that Your Honor has heard all the evidence, that he's a journalist, he's a commentator. Flow Sports is more like a ESPN or a Fox Sports or NBC Sports. And because of the impermissibly broad restriction they're trying to impose, this non-compete is either not enforceable or at a bare minimum, like Ms. Klingheisen said, Your Honor reformed it back in January, December, January, when the injunction was put into place. And because of that, their only remedy was injunction and they're not entitled to damages. Also, Mr. Woke admitted, not knowing why he was being asked this, that the definitions that Flow Sports has offered this court are inaccurate. He doesn't even agree with those. They're too broad. And Mr. Brutico pointed out in his examination of witnesses, and the witnesses testified that no one has left Flow Sports because they didn't have enough to read. They left because they didn't have enough to watch. And there's a big difference between one and the other. And you've heard about Rockfin, and you understand that platform. So I want to touch on the last few claims as I get close to wrapping things up. With regards to solicitation, there are, I believe, two leading Texas cases on this, the Urquhart case and the In re Athens case. This is Justice Busby's opinion. This says solicitation does not mean merely asking. And it doesn't mean a passive thing like posting something like a LinkedIn notification or something like that. Solicitation requires more, a coaxing and encouragement. There's no evidence. First of all, there's zero evidence that he solicited any employee or targeted any specific customer to stop using Flow or stop being a subscriber and then move over and be somebody who's on his Math Scouts channel. Frankly, the damages testimony, and I'll be careful because I know it was all in closed courtroom, but I'll be kind and say it was underwhelming. The amount and the things that they described were what I would consider de minimis. And when you look at, Your Honor, the actual documentation, and Mr. Brutico was extremely thorough in going over with Mr. Jordan, the causes why people said they left. None of those have to do with improper solicitation or improper competition or anything like that. Finally, the last claim is non-disclosure. And this, time and time again, I pressed them on it, and all they can come up with is that Ben Askren tweet. We know that didn't cause any damages. It's not a viable claim, et cetera. So we've talked a little bit about the chronology in 2019. Now that Your Honor's heard the evidence and we can see the chronology in 2020. So what happens? Your Honor enters the temporary injunction, and Flow Sports seizes on that as part of their bullying campaign and retaliate against Mr. Saylor by taking his stock options. Then March 13th, everybody in the world is affected, certainly in the country, by COVID one way or another. And what the impact that has had on this case, and the reason we're talking about it in this case, is because Flow Sports is all about live events and live sporting events, all of which came to a grinding halt across all different sports for a long time. And so to the extent that Flow Sports, who has had any difficulties or what have you this year, they are for reasons unrelated to Willie Saylor or Rockfin. They're because of no live events and because of the challenges that they had, frankly, with the way they've dealt with women wrestling. November 3rd, 2020, very important date. And I'm going to talk about this at the end too, Judge. It has been a year. This thing has expired. It's time for this case to stop. So with regards to Flow Sports' remedies and what we're asking from Your Honor on those, first of all, on the competition, Mr. Saylor has been enjoined effectively since December 18th, 2019. That was when the TRO was signed, when Mr. Machuca signed that affidavit. That is their remedy. They've had their benefit of their bargain, et cetera. The non-compete is now expired by its own terms, and there's absolutely no reason to justify extending, as Ms. Burgess has said, which frankly, I think is contrary to 1552 of the Civil Practice and Remedies Code, because it's that agreement is trying to alter what the law provides for. And that provision is so strong at saying, if you want to have a non-compete, it needs to conform with these things, and things that are contrary to it are effectively preempted. It's also a limitation on damages. I will further remark, Your Honor, that with regards to the claims for lost profits, Flow Sports has failed to meet the standards of having to show a track record of profitability, profits lost with reasonable certainty, and any causal link between either Mr. Saylor or Rockfin to any lost profits. Mr. Jordan's numbers are wildly speculative, and I think the canceled reasons that you can see in Defendant's Exhibit 181 are just one of the many reasons why there has been no proof of real damages. I've mentioned the no damages caused by any wrongful conduct of Mr. Saylor. And again, the fact that Mr. Saylor left, he was at will. if they thought he was a talent that needed to be kept for 4 years, they should have put him down on a 4-year contract. The unjust enrichment is not a proper remedy for breach of contract. And so what we're respectfully asking the court is to come back with a finding of 0 damages on Flow Sports claims against Mr. Saylor. With regards to our own relief, and my last set of comments to the court, we would like confirmation, ideally today, that the temporary injunction, well, the non-compete has expired on its own terms. The injunction has expired on its own terms, but we would like confirmation that it's been dissolved of the amended temporary injunction, which ran through, I think, October. Number 2, that Flow Sports take nothing. 3, that Mr. Saylor be awarded the fair market value of his stock options, and we provided that evidence to Your Honor as to what Flow Sports has represented was the value in January of 2020 when they were taken away. We'd like the bond money that's been posted with the court to be released to us, to Mr. Saylor. And finally, Your Honor, we would respectfully request the opportunity for us to come back and for us to be able to present our attorney's fees on the bad faith claim under trade secrets, as well as CPRC, and I should have put in there under breach of contract, Chapter 38, as well as fraud in stock transaction, but there's already too many words on that page. Your Honor, I very much appreciate, Mr. Saylor appreciates your time, your attention to all the parties throughout this case, and thank you.
Thank you, Mr. Soltero. Ms. Burgess, you get the last word.
Thank you, Judge. And I'll really, truly be brief. I'm just going to start quickly with the stock option claim. Not only did Mr. Saylor admit that he has absolutely no evidence of it, we showed that in the previous slides, but the stock incentive plan itself, which is F64, says that during the 90 days that you have to exercise your stock options, you can't do anything you couldn't do while you worked at Flow Sports. It's undisputed here that Mr. Saylor could not work at both Flow Sports and Rockfin. Beyond that, he did plenty of things that also constitute cause under that paragraph. So I would urge the court to look at 2.1D of the stock incentive plan if you're even entertaining that issue. Besides, on 38001 would not apply at all. It's governed by Delaware law that doesn't have a corollary provision. You may know that that's kind of unique to Texas. Let's go to the first slide. I just have 4 or 5 slides here. So we heard about, from Rockfin, we heard about the fact that we heard about Mr. Walk's testimony. He testified, he made a big distinction that was not made in the closing, and that's Roku hardware versus Roku channel. And that's something that you heard in the testimony and something that you can see in the dailies as well. Now, he also talked about targeting tobacco versus Ford trucks. Here, we're Chevy trucks versus Ford trucks. Both drive, both give you wrestling content, both behind a paywall for roughly the same amount. Now, let's go to the next slide. I'm glad that Rockfin emphasized platform versus publisher, because those are labels that they would like to apply and then conclude without any evidence that a platform can't compete with a publisher. The evidence is clear that they did compete successfully. In fact, Rockfin successfully competed to host the Nittany Lions wrestling event on Rockfin and shifted a substantial amount of value to Rockfin. Then Saylor used his head start to compete on content, which are products and services in the sports video industry, to flip subscribers. Products and services. Also, as you heard from Rockfin, the first part of the non-compete doesn't require that definition at all. Now, the court shouldn't follow these semantics. Just observe what actually happened. Mr. Floriani himself said that Facebook was a direct competitor with Flow Sports. Flow Sports has dozens of Facebook pages and Facebook audiences, and yet Facebook is a direct competitor of Flow Sports. Rockfin is just like Facebook, even if you want to call it a platform versus a publisher. go to the next slide. The defendants would like to have it both ways on Mr. Saylor's longevity at Flow Sports. They both say that he woke up the next day after he quit and didn't realize he had quit and was surprised that he had quit. And so was shocked that he was eventually going to be cut off from access. Unfortunately, he took that one day to get in and download or get in and look at Periscope, not just to get his attributions, which he could have done in a lot less than 71 minutes, which is the testimony of what he spent in Periscope after he quit. Additionally, Mr. Piles testified that they had just given him a raise. They had just increased his commission by almost 20%, raising his per subscriber attribution commission by $5 from 35 to 40. So a significant change. Now, you can just, okay, here you just stay here. This is good. Now, we also heard Rockfin say that there's no evidence that Rockfin did anything to cause Saylor to leave. You've seen a lot of these texts, and I would urge you to keep looking at them. But it took 9 months of persistent pursuit, a $10,000 signing bonus, W-2 employment, health insurance, studio equipment, multiple plane trips back and forth. Other than that, I guess there is no evidence, but that's a lot of evidence. Now, you also heard the defense say that one of the differences between Flow Sports and Rockfin is that Rockfin does not have licenses or rights to stream. But here in their own terms of service, on their own website, they gain a license for everything that goes on that. So when they exclusively streamed the Nittany Lions event, they had a license to exclusively stream the Nittany Lions event. Just stay where you are right there. Now, with regard to the computer claim, that was denied as a matter of law on summary judgment by Judge Jenkins. And while we're talking about Judge Jenkins' rulings on summary judgment, he also ruled on the First Amendment issue. When Your Honor made carve-outs to the temporary injunction, and I know you'll recall this, I don't have to remind you, but that was the concern. There was no formal legal reform of the non-compete at that time. I would wonder whether a court could reform a non-compete without telling the parties it was doing that. But even if you did that, it was subject to the First Amendment ruling that went to Judge Jenkins and went for Flow Sports. I thought it was interesting that we heard that when Mr. Saylor kept all the information on his G Suite, he did that because it was his personal work. Of course, the agreements are clear, they cover that, but we hear that in every single case like this. I did this on the side, even though it's exactly what I was hired to do as a full-time employee. We hear that in every case, and I know you've heard it so many times. Now, let's go to the last slide here. It's been almost a year since we were before you on a temporary injunction. But you'll remember that way back in December of 2019, the defendants vehemently argued that they were not competing because they did not live stream events. And this is a statement that the court made, that if they're about to go into live streaming, it would be direct competition. Your statement was prescient and accurate. Rockfin and Floriani and Saylor were excited about live streaming. That's how you get, I think Mr. Machuca talked about baking a cake. You get the content and the live streaming together, and that's what makes it happen. They were excited about that, and then they did it. Mr. Saylor has breached his agreement and misappropriated Flow Sports trade secrets, and Rockfin, with full knowledge of that agreement, has encouraged him to help him do it, and that has shifted enormous value from Flow Sports to Rockfin. We heard the argument that you can't trap his brain. That's why you have a non-compete, so that you can keep his brain from using the information that it learned at Flow Sports to go out and directly get a head start, much less with the ranking spreadsheets that he took. What's so important about rankings and recruiting information? You heard that question. The importance is the head start, and the significance is right there in the value that was shifted away from Flow Sports and to Rockfin. That is exactly the flywheel. That's what Mr. Floriani was talking about in February of 2019, and it's exactly what's happened. And Judge, we appreciate your time and consideration.
Okay, when do you all want to schedule these attorney's fees? And let me ask about a process, first of all. How do you want to do it? Do you want to do it by affidavit? Do you want to do it by hearing with question and answer of lawyers testifying about fees? What's your pleasure in terms of how you want to do it? And secondly, when you want to do it?
Your Honor, I have a question about that. Would it make sense to know whether Your Honor's going to award fees before deciding who's going to testify? It may shortcut the process if we had a.
I don't
If we had
understand
a,
the question.
sure, all the sides are asking for attorney's fees. So sometimes if there's a determination as to who's entitled to fees, it might shorten the process. But if Your Honor wants to hear all the evidence first, I would suggest we try to confer about doing it by affidavit. If not, I'm ready to do hearing next week.
I want to hear all the evidence first.
Okay, in that case, I think we're available next week,
I'm not.
Monday or Tuesday.
No dockets next week.
Okay, whenever Your Honor wants us here, we'll be here.
And when you said hear all the evidence, I think Mr. Soltero suggested by affidavit. I'm open to either way. So
Doesn't matter to me.
I
I just want that information before I issue my ruling. So doesn't matter how you do it. Just agree on a process. I'll do it either way. And I want it before I make a ruling.
Okay.
Y'all want to talk about it? I mean, it doesn't matter to me. I can't do it next week. There are no dockets next week.
I suggest that we talk about it, Your Honor?
Sure.
Okay.
You must agree on the process, right? I don't want to have to fight about whether or not somebody has an objection to somebody's affidavit if you're going to pick that. I'm not going to do it both ways. So agree on a process, agree about what you're going to do, and let's do that. And it does not matter to me which option you choose, but you need to have an agreement on how you're going to do it. I'm not going to entertain argument about half-stepping some sort of process. So happy for you to do that. Just contact Mr. McCabe when you're ready, and we'll schedule something if you decide you need to have a hearing. And if you decide to do it by affidavit, that's fine too. If you do that, you'll need to mark as exhibits the additional information, and we'll get those admitted per your agreement as whatever exhibit number you have next on your list. If you don't do it that way, we'll schedule a time for a hearing. You need to let Mr. McCabe know when you're available and how much time you need, and we'll get you scheduled on our docket. In the meantime, I have got to give the court reporter a break. And
Your Honor,
can
I ask where we are on whether the injunction is in effect or not?
Well, I believe that the injunction is in effect until I make a ruling, I think. But I'm frankly of the opinion that the non-compete has expired. And so I don't see the point of keeping the injunction in place at this point, after I've heard all of the evidence. I realize that Ms. Burgess has made an argument that it should continue for some additional period, but frankly, it seems to me that if in fact Flow Sports is to be compensated for any wrongdoing by Mr. Saylor over at Rockfin, that they will be made whole by whatever damage award they receive. But the non-compete has expired, and so too should the injunction. So the injunction is dissolved. And a bond can be returned. Okay, well, listen, it's a couple of things. 1, been a pleasure. 2, happy Thanksgiving. 3, hope you all stay safe and stay well. And I'll wait to hear from you about the rest of these matters that need to be tied up. I know Ms. Baker is going to get me some information. You all need to give